An ancient legend tells of a wise ruler who wanted to ensure that his people were encouraged and inspired to live lives of righteousness and compassion. He wanted to give them a motto, as it were, a mission statement, we might say. So he called together his sages and wise council, and they cogitated upon this and came back a few days later to report that they had 4 words. This too shall pass. I'm reminded of that in the Bible many times. It's certainly from Psalm 23, verse 4. Yea, I walk through the valley of the shadow of death, I will fear no evil, for you are with me, your rod and your staff, they comfort me. Speaking of God's promise to be with us, we are assured, therefore we don't fear. But I think the most significant word in that verse is the word through. We walk through the valley. We're not stuck in it. We're not condemned to stay there. We are not without a choice. We can pass through. Because whatever situations we're in, whether good or bad, pleasant, uncomfortable, joyful, sorrow, they shall pass. Now, God's promise to be with us is great, but it is not to commiserate with us. It is rather to empower us to go through. Let us pray. Gracious God, we thank you for this new day and for every opportunity it brings to serve you and to serve others. We pray your blessing on all gathered here in the leadership of our country and the staff who assist them in their duties. Help us to remember, Lord, that life will take us through many situations. Some will be dark and difficult. Some will challenge every fiber of our being. But we have the assurance that you are with us, and we will get through. Strengthen in us all that is good and right, and empower us to live lives that are pleasing to you. In the name of the Father, and of the Son, and of the Holy Spirit. Amen. We join in the prayer Jesus gave us. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come. Thy will be done on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. And lead us not into temptation, but deliver us from evil. For thine is the kingdom, the power, and the glory, forever and ever. Amen.
Good morning, Senators. This is the morning session of the Senate of the 16th of May, 2024. The first item on the agenda is the adoption of minutes.
Morning, Madam President. Madam President, I move that the minutes of the session of Senate held on Thursday, the 9th of May, 2024, be adopted.
Is there a seconder?
Second.
It has been moved and seconded that the minutes of the meeting of the Senate held on Thursday, the 9th of May, 2024, be adopted. As many as in favor say aye. Aye. Those opposed say nay. The ayes have it. The motion is carried. The minutes of the Senate meeting of Thursday, the 9th of May, 2024, are hereby adopted. Motions for leave of absence, swearing in of new senators, communications by the President, appreciation is extended to our chaplain who is sitting in for Reverend Carla Culmer, Reverend Higgs. We appreciate your coming to lead this morning's devotion. The Senate President also extends heartfelt condolences to the family of the Honorable A. Loftus Roker. I will have more to say about this later, but he will go down in history for a legacy of one who was a nationalist, one who placed this country, the Bahamas, above party politics. He was a hero, a man of law and order, a disciplined person, a forever statesman, and an excellent politician. And we thank God for his legacy. And we also want to remind the family, in the words of our chaplain, although you may be experiencing a very difficult time at this moment, nothing can separate us from the love of God. And as you walk through your valley experiences, please know that God is forever with you. And I thank you for sharing him with us for all of those many years in political life. Messages from the Governor General. Messages from the House of Assembly.
Message from the House of Assembly.
Bahamas number 16. Message to the Honorable the President, honorable members of the Senate, from the Speaker and representatives of the Honorable House of Assembly. The House of Assembly acquaints the Honorable the Senate that they have agreed to the following resolution and desire the consent of that Honorable Chamber, namely, now therefore be it resolved that pursuant to Section 5(3)(a) of the said Ministry of Finance Act, Chapter 23, for a sum to be agreed by the Minister of Finance not exceeding $50,000 in the said currency, this House approves the conveyance by the Treasurer to Abaco Medi Center Limited of the said hereditaments. House of Assembly, Nassau, 15th May 2024. Patricia DeVoe, Speaker.
Laying of documents.
Thank you, Madam President.
Chair recognizes Senator the Honorable Michael Halkitis.
Thank you, Madam President. Madam President, before I lay documents, I just want to briefly share in your sentiments, the sentiments that you expressed on the sadness on the passing of one of our founding fathers, the Honorable A. Loftus Roker, Madam President, and just to indicate that at an appropriate time, perhaps at the next sitting, we will set aside time to pay proper tribute to our fallen brother. So, Madam President, I beg leave to lay on the table of the Senate a copy of the following: the Cannabis Medical Cannabis and Recognized Jurisdictions Order 2024, the Health Professions Amendment to the First Schedule Order 2024, the Rehabilitation of Offenders, Expunging of Records, Indian Hemp Offenses Order 2024, the Cannabis Regulations 2024, the Health Professions General Amendment Regulations 2024, the Hospitals and Healthcare Facilities General Amendment Regulations 2024, the Dangerous Drugs Prescription of Minimum Amounts Amendment Rules 2024, the Dangerous Drugs Application Order 2024.
Order the documents be brought up. Order that the documents do lie on the table. Further laying of documents. Thank you.
There are none at this time, Madam President.
Thank you, Senator Halkitis. Communications by ministers. Communications by senators. Questions. Answers to questions. Presentations of petitions. Appointment of select committees. Report of committees. First reading of bills. The chair recognizes Senator the Honorable Michael Alcides.
Thank you, Madam President. I beg leave to lay on the table to introduce, beg leave to introduce and have read for the first time a bill for an act to provide for the establishment and licensing of cannabis dispensaries.
Is there a seconder? Order the document be brought up. It has been moved and seconded that the following bill be read for a first time and tabled. A bill for an act to provide for the establishment and licensing of cannabis dispensaries. As many as in favor say aye.
Aye.
Those opposed say nay. The ayes have it. Order the bill be read for a first time.
A bill for an act to provide for the establishment and licensing of cannabis dispensaries.
For the first reading of documents.
Thank you, Madam President. Madam President, I beg leave to introduce and have read for the first time a bill for an act to amend the Dangerous Drugs Act.
Is there a seconder? It has been moved and seconded that the following bill be read for a first time and tabled. A bill for an act to amend the Dangerous Drugs Act. As many as in favor say aye. Those opposed say nay. The ayes have it. The motion is carried. Order the bill be read for a first time and tabled.
A bill for an act to amend the Dangerous Drugs Act.
For the first reading of bills.
Yes, Madam President, I beg leave to introduce and have read for the first time a bill for an act to regulate the handling of cannabis and the establishment of the Cannabis Authority.
Is there a seconder? It has been moved and seconded that the following bill be read for a second time and tabled. A bill for an act to regulate the handling of cannabis and the establishment of the Cannabis Authority. As many as in favor say aye.
Aye.
Those opposed say nay. The ayes have it. Order the bill be read for a first time and tabled.
A bill for an act to regulate the handling of cannabis and the establishment of Cannabis Authority.
For the first reading of bills.
Thank you, Madam President. I beg leave to introduce and have read for the first time a bill for an act to amend the Civil Aviation Act.
Is there a seconder? It has been moved and seconded that the following bill be read for a first time and tabled. A bill for an act to amend the Civil Aviation Act. As many as in favor say aye.
Aye.
Those opposed say nay. The ayes have it. Order the bill be read for a first time and tabled.
A bill for an act to amend the Civil Aviation Act.
For the first reading of bills.
Madam President, I beg leave to introduce and have read for the first time a bill for an act to amend the Civil Aviation Authority Bahamas Act.
Is there a seconder? It has been moved and seconded that the following bill be read for a second time and tabled. A bill for an act to amend the Civil Aviation Authority Bahamas Act. As many as in favor say aye.
Aye.
Those opposed say nay. The ayes have it. Order the bill be read for a first time and tabled. I'm gonna need y'all
A
to.
bill for an act to amend the
Comment.
Civil Aviation Authority Bahamas Act.
Yeah, y'all disturbing me. For the first reading of bills, please.
Madam President, I beg leave to introduce and have read for the first time a bill for an act to update and modernize the law relating to the regulation of securities exchanges and the securities industry, to expand and enhance the powers of the Securities Commission, to repeal the Securities Industry Act, Chapter 363, and for connected matters.
Order the bill be brought up. Is there a seconder? It has been moved and seconded that the following bill be read for a first time and tabled. A bill for an act to update and modernize the law relating to the regulation of securities exchanges and the securities industry, to expand and enhance the powers of the Securities Commission, to repeal the Securities Industry Act, Chapter 363, and for connected matters. As many as in favor say aye.
Aye.
Those opposed say nay. The ayes have it. order the bill be read for a first time and table.
A bill for an act to update and modernize the law relating to the regulation of securities exchanges and the securities industry, to expand and enhance the powers of the Securities Commission, to repeal the Securities Industries Act, Chapter 363, and for connected matters.
For the first reading of bills,
Yes, Madam President, I beg leave to introduce and have read for first time a bill to regulate the issuance, sale, and trade of digital assets in or from within the Bahamas, and to repeal and replace the Digital Assets and Registered Exchanges Act 2020.
is there a seconder? It has been moved and seconded that the following bill be read for a first time and tabled. An act to regulate, a bill for an act to regulate the issuance, sale, and trade of digital assets in or from within the Bahamas, and to repeal and replace the Digital Assets and Registered Exchanges Act 2020. As many are as in favor say aye. Aye. Those opposed say nay. The ayes have it. Order the bill be read for a first time and table.
A bill for an act to regulate the issuance, sale, and the trade of digital assets in or from within the Bahamas, and to repeal and replace the Digital Assets and Registered Exchanges Act 2020.
For the first reading of bills,
There are none at this time, Madam President.
second reading and committal of bills. The chair recognizes Senator the Honorable Ryan Pinder.
Thank you, Madam President, and good morning, colleagues. Today I rise to move for the second reading of the Trial by Judge Alone Miscellaneous Provisions Bill 2024, and as a compendium, the Supreme Court Amendment Bill 2024, which allows for the Supreme Court Criminal Case Management Amendment Rules 2024. Madam President, these bills are in line with the commitment of our government to ensure that the necessary laws are in place to facilitate the timely and the effective administration of justice. We have been working hard this legislative session to put in place the improvements in law to address the judicial system, as well as the treatment of bail for an accused, and ensuring that there are stiff penalties for major criminal violations. Madam President, before addressing the specific bills before us today, I think it helpful to set out our legislative agenda on judicial and criminal justice, to appreciate where we have come from and to appreciate where we are going. Madam President, we have passed a series of legislation to facilitate trials and the prosecution of criminals in our country. I would suggest that we have done more on the legislative front than any former administration to address crime. And I want the Bahamian people to know we are not done. We will never be done to protecting the society and the citizens of the Commonwealth of the Bahamas. Madam President, the Magistrates Amendment Bill increased the financial thresholds for the jurisdiction of a magistrate to hear certain matters and adjusted maximum penalties. We passed that last year. Yes. The broadening of the jurisdiction of the Magistrates Court is intended to rebalance cases between the Supreme Court and the Magistrates Court in order to relieve the volume of minor disputes from the calendar of the Supreme Court. The Magistrate Court is in many instances the primary court for many civil and criminal cases, and especially in civil matters operating more of a small claims court. When we expanded the jurisdictional limits and we increased those, they had never not been done in many years prior to that, more than a decade. And certainly the operation of society had outpaced the limits that were in law at the time. We're pleased to have made that progressive reform. Another legislative reform that we have accomplished, Madam President, in our journey towards reforming the judicial system is the Court Services Bill. This bill empowers the judiciary to operate autonomously from an administrative point of view by taking away oversight by the central government, thereby removing a bottleneck caused by the current system and providing more judicial independence. As currently constructed, although the judiciary may have its own budget head, the Financial and Employment Administration largely is managed by central government, and in this instance, through the Office of the Attorney General. It's of note that the Court Services Council is a body that is being appointed to manage all matters relating to the administration of the courts. A chief executive officer is to be hired, who is the principal administrator of the council, and who shall be subject to the directions of the board. Madam President, we see this act and the establishment of the Court Services Council as a significant move in the direction of good governance for judicial operations. It provides administrative independence from the central government and will allow for the more efficient administration of the courts and the judiciary, which ultimately means a more efficient administration of justice for all. Madam President, the Court Services Act will come into force on July 1st, 2024. Madam President, Supreme Court Amendment Bill, which we debated in 2023. This bill increased the maximum number of Supreme Court judges from 20 to 25. This is a significant amendment that we made, increasing the capacity to conduct trials in the Supreme Court by 25%, a full quarter. Madam President, it is the government's intention that this will not only contribute significantly to concluding the backlog of cases, but will also give the Chief Justice more flexibility that he requires to better allocate judges throughout the courts. The number of judges hearing criminal matters will naturally be increased. This will also allow the Chief Justice to properly implement the specialty court framework, being able to allocate judges on specialty court matters. For example, we anticipate in the coming months that we will open the juvenile and family courts on Burnett Road, allowing us to utilize existing infrastructure to bring on new judges in the criminal and civil courts. We also anticipate this year a commercial court that will be focused on hearing commercial disputes to ensure that the pace of business is not impaired by the delays of trials. Madam President, as you would know, we passed the Bail Amendment Bill, and for the first time sets out a detailed legislative guidance on the issuance of bail. The legislation, which the other side voted against, requires an accused granted bail to enter into a recognizance of bail, which shall contain the conditions to which the grant of bail is subject. The form of the recognizance of bail, or the agreement of the bail, is attached as a schedule to the bills, so everybody knows in full transparency what they are agreeing to. Section 9A3 of that bill is an important section, Madam President. It provides that the breach of any conditions contained in the recognizance of bail shall result in the bail, that agreement, becoming void. This section underpins the principle of the Davis administration that the breach of bail terms that an accused has affirmatively agreed to comply with is a serious offense and mandates that that agreement of bail be revoked or be void. The legislation provided 3 mandatory conditions of a recognizance of bail, things that you must agree to in order to get bail. These conditions are that you do not commit an offense while on bail, naturally, if you're granted bail, you should not be going and creating other criminal offenses while on bail. You shouldn't interfere with a witness. And you should agree to duly appear at the time and place of trial or an adjourned hearing and not depart the court without leave. Basic principles of which you agree to, conditions of your bail. And I don't think anybody can argue that those are unreasonable conditions. For the first time in law, they are mandated conditions of your bail. That's what we passed when we passed the Bail Amendment Act. Madam President, an important aspect of the Bail Amendment Bill is if any conditions of the bail are breached, any conditions. I just gave you the 3 mandatory conditions. But there could be other conditions, such as removing an ankle monitor, or breaking your curfew, interfering with a witness, that these breaches of your conditions of bail are an offense. And remember, you've agreed not to conduct or undertake a criminal offense while on bail, and thus any conditions breached in your recognizance of bail results in that agreement to be void. That's what we passed. We're tough on crime. They voted against it. Mr. Vice President, welcome back.
Thank you.
We also passed, Mr. Vice President, the anti-gang bill. The anti-gang bill is an important piece of legislation in the fight against crime. The anti-gang bill makes provision for maintaining public safety and order by discouraging memberships in gangs, suppressing and punishing the participation of gang members in serious offenses and in gang-related activities. The bill makes it unlawful to be a gang leader or a gang member and prescribes the evidence which is admissible to prove whether you are a member of a gang or not. The anti-gang bill is a tough-on-crime measure, providing for serious offenses for gang activity and committing offenses when you are a member of a gang. Mr. Vice President, our legislative agenda on criminal justice matters to date is crystal clear. Crystal clear. It's aggressive. It's pursuing the necessary reforms in the administration of justice to ensure timely trials, responsible prosecutions, while still being tough on crime, Mr. Vice President. The legislative agenda is clear. We have passed legislation intended to make the operations of the judiciary more robust, more efficient, ensuring that the capacity exists to conduct the trials and that the capacity is allocated in the proper court forums, such as expanding the jurisdiction in the magistrate court. We have also legislated, Mr. Vice President, to ensure that the administrative functions of the judiciary are maximized with the greatest efficiency. These are all important factors to ensuring that cases and trials are heard timely. We've heard the discussion about backlogs in cases and how long it takes to get to trial and how this results in granting bail. And the criticisms are real, but the criticisms are being addressed in law, Mr. Vice President. Our legislative agenda on the criminal justice system is crystal clear. We're also legislating in the criminal justice system to be tougher on criminals, evidenced by the Bail Amendment and the Anti-Gang Act. And Madam President, we're not done in this regard either. The bills we debate today are focused on developing further efficiencies in conducting trials in our criminal justice system. The ability to try accused persons in the Supreme Court within a reasonable time is often impacted by various factors, including the availability of jurors. Jurors are sometimes unavailable because they're self-employed, like you, my friend, or where they're employed, their employers, even though not right, are unwilling or unable or cause the difficulties in attending juries. Moreover, jurors themselves are often reluctant to serve because of fear of recrimination from persons on whose cases in which they sit. They're scared of retaliation by sitting on a jury. That's a fact. Together, these circumstances lead to lengthy delays in bringing accused persons before the Supreme Court in trial. It's true. Consequently, courts may be unable to fulfill their mandate of a trial within a reasonable period of time, and therefore are obliged by the Constitution in Article 19 to release the accused on bail. So you see how these all add up, Madam President, and how ultimately what we are trying to do is to be in a position to conduct trials more efficiently, more timely, to bring the administration of justice in a more predictable and shorter time frame. To one, so we're not obligated to grant bail when it's unnecessary to do so, but two, also ensure that those who are innocent are set free, and those who may be guilty are punished, and then when they are punished, Madam President, our agenda is to punish them with the full strength of the law. Recently, a cadre of legal luminaries, including the former Chief Justices, which includes the current President of the Court of Appeal and the President Chief Justice, have suggested that the option of trial by judge alone might be a way to alleviate the need for some jury trials, provided the accused person is given the option to decide before trial. The Eugene DePuch Law School hosted a full panel discussion on this topic, of which these esteemed luminaries had very specific and pointed recommendations. I am of the view that this measure will greatly assist in reducing the time within which persons charged with indictable offenses are tried in the Supreme Court. To this end, Madam President, we debate today the Trial by Judge Alone Miscellaneous Provisions Bill 2024. To grant the right of election to persons charged with indictable offenses in the Supreme Court to be tried by judge alone. After this bill is passed, accused persons on arraignment in the Supreme Court may waive their right to jury trial and elect trial by judge alone, but only after they have either sought or received legal advice or waived their right to such advice. The proper due process considerations have to be considered. The bill also provides for the application of the Act to persons who are charged on indictment prior to its commencement, but whose trials have not begun at the commencement of the Act. So if you are currently charged and your trial has not commenced, and then we pass the Act and it comes into force, as long as your trial hasn't commenced, you likewise have the right to elect. The bill sets out the jurisdiction of the judge in a judge-alone trial and provides for judges to sit as judges of the law and of the facts, and requires them to give reasons for their decision. This is a very significant benefit of the judge-alone trial, because juries don't have to give the reasons for their decisions. In a judge-alone trial, you will get the benefit of written reasons on the decision, which, Madam President, can greatly help if you choose to appeal the matter or not. We believe this is a positive legislative reform to provide yet more support for timely trials in criminal matters. Consistent with the agenda that I have laid out of this government in addressing criminal justice matters from the beginning of this legislative session. Madam President, we also debate today the Supreme Court Amendment Bill 2024. This bill allows for the Supreme Court Criminal Case Management Amendment Rules 2024. The Supreme Court Amendment Bill seeks to amend Section 76 of the Supreme Court Act to specifically authorize the making of rules for the active management of both civil and criminal matters before the Supreme Court. Pursuant to the amendment in Section 76 of the Supreme Court Act, the Supreme Court Criminal Case Management Amendment Rules were drafted to give more power to the judges of the Supreme Court to actively manage criminal cases, to ensure that the cases progress efficiently, effectively, and fairly. In this regard, the rules propose that evidence, whether disputed or not, is identified early in the trial and presented at trial in the most effective and efficient manner. These are technical amendments, but they're important because frequently we see trials delayed by matters of basic disputes over evidence throughout the trial itself, from beginning to end, which causes disruption in the timely completion of the matter. And we even see, and I hate to cast aspersions on my learned friends, but we also see that certain defense counsel may use this as a tactic to delay the trials for their clients. Something that all bogs down the progress of criminal trials in the courts. So these are technical rules, but they're important rules. They're important rules to create more efficiencies in operations within criminal trials within our system to achieve what our ultimate goal is: to clear the backlog and ensure that trials are heard in a timely and efficient manner. The rules were drafted on the instructions of the Rule Committee to assist in reducing the delay in disposing of criminal matters. Towards that end, these rules seek to empower a judge to hold directions hearings throughout the course of the trial process, which in the court's discretion may include a pre-trial evidentiary hearing. So you may have the court decide that they want to have an evidentiary hearing before the trial starts to deal with all matters of evidence and disputes on evidence before it starts. So when the trial actually starts, there's no delay. According to the rules, directions for pre-trial evidentiary hearings may require the accused person to identify matters of fact in the prosecution's case which they dispute and reasons why, any objection to the admissibility of any evidence to be led by the prosecution and the basis for that objection, and any statutory or legal authority on which he intends to rely on. So a pretrial evidentiary hearing allows the accused to dispute the legitimacy of evidence that is going to be used in the trial against him up front, dealing with that issue before the trial commences. The judge managing the case may also require the accused person to set out in a defense statement. So they may require a defense statement by the accused that sets out the particulars of the facts on which he intends to rely for the purposes of his defense, the nature of his case on which he intends to rely at trial, and the identity of witnesses he intends to call. So all of these procedural evidentiary matters are dealt with up front. Moreover, the judge may direct the prosecution, so there's balance here. He can ask the defense or the accused to provide information, but then he also will ask, the judge can ask the prosecution to provide preliminary information on evidence. And this includes any evidence in the case of the defense which it says is inadmissible or should be excluded. So we don't have fights in the middle of the trial about whether the evidence should be admissible or not. Let's deal with that up front. So when we actually get in the trial, we dispose of the matter timely. That's the responsible thing to do. They also could look for the prosecution to detail the grounds on which any evidence of the defense might be excluded. The ruling of a judge in any pretrial evidentiary hearing shall be binding on all parties, so it's a binding decision, until the case against the accused person or persons, if there's more than one, is disposed of. We believe, on this side, and I'm glad in this instance we look to have the support of the opposition, but we believe, as does the Chief Justice and the Rules Committee, that this technical amendment and evidentiary rule will contribute greatly to the efficiency and the timeliness in which criminal trials are heard. The delay of trials as a result of evidentiary matters will be greatly reduced. The ability for the defense bar to utilize strategy during trial of disputing evidence will be reduced. The Bahamian people should know that we as a government will do everything we can to ensure that justice is thorough, swift, and efficient. Madam President, this isn't the end of our focus on legislating to facilitate the administration of justice. Again, as I explained in the beginning, we have a legislative agenda, well thought out and planned, to be tough on crime and to ensure that the administration of justice within our courts is done efficiently and effectively. That's our strategy. Madam President, we will soon be bringing a new Firearms Act to Parliament. The present Firearms Act was enacted in 1969, with numerous piecemeal amendments made up to 2014, but still none within the last 10 years. Times have changed in the Bahamas. That's not rocket science. Times have changed in the Bahamas. Firearms technology has advanced, and sadly, we have not kept abreast of either. The new Firearms Bill, 2024, will have a much wider coverage of illegal firearms, including gun kits, assembling firearms from kits, as well as the production of 3D firearms. Did you know that using a 3D printer, you can print the components of a firearm, assemble it, and have a working firearm? And that is being done in this country right now? Right now. With no legislation that contemplates firearms in that regard. The bill will apply specifically to ghost guns, which are inherently dangerous, are unregulated, have no manufacturer's name attached, no serial number attached, and are impossible to trace. We have those on our streets right now. Guns that are impossible to trace. In the firearms bill, we will prohibit the acquisition of high-powered firearms, assault weapons, submachine and machine guns, and any component parts thereof. We will forbid ammunition for these types of guns and any accessories which may be used to convert a licensed firearm into a prohibited firearm or weapon. You know, we have persons who have licensed firearms, properly licensed firearms, who then convert them into a automatic type of a weapon or other a weapon which is not a licensable firearm. And because we don't have firearm inspections, there's no way for you to actually know that they have done this to a licensed firearm. All you do is renew your license. We will call for routine inspections of licensed firearms. We are considering restricting persons with criminal records, persons with mental illness, persons with alcohol or substance abuse disorders, and those who are unable to demonstrate competence by completion of a gun safety course from being granted a firearm license or a renewal of that license. The new firearms bill will be all-encompassing, having broad application, and will go a long way to addressing the scourge of firearms in our country. Madam President, we likewise will soon be bringing amendments to the National Crime Intelligence Act that will create a better framework for the intelligence of ongoing criminal activities in the Bahamas. Intelligence is a fundamental tool to help beat back the scourge of crime, especially organized crime within the Bahamas. So we pass an anti-gang bill that creates a host of serious offenses for being a member of a gang or committing crimes while being a member of a gang. But in order to properly implement that, you need proper intelligence. My law enforcement friend will tell you, intelligence is key and paramount to collecting the evidence necessary to prosecute under these laws we're passing. So we will be bringing an amendment to the National Crime Intelligence Act to better facilitate the gathering of intelligence, especially in the context of organized crime. Maximizing the intelligence capability of law enforcement is fundamental to the fight against crime. Madam President, the Davis administration has a distinct and specific legislative agenda on the fight against crime and, in tandem, the effective administration of justice. We are hard at work at addressing these long-standing issues. The administration of justice will see a marked improvement. The delays in court will be reduced, and the circumstances of granting bail will be significantly altered by the bills and the actions we take in this place. We are tough on crime. We are committed to improving our criminal justice system, and we are dedicated to the law and order in our Bahamian society. With that, Madam President, I move for the second reading of these bills. Thank you.
Thank you, Senator Ryan Pinder. Is there a seconder? The chair recognizes Senator the Honorable Barry Griffin.
Good morning, Madam President. It's great to be back in this place.
That was Brazil.
Wonderful. Lots of goodies for the Bahamian people. And it's great to be Bahamian, Madam President. Every year as spring rolls out and the summer heat begins to take over, I feel an extra sense of pride as a Bahamian. This is our time to shine. The summer is our time to show the world why we are the most beautiful country in the world. Our vibrant sun, sand, and sea are on display for all. Madam President, I'm also extra proud to be Bahamian during this time because I know that independence is on the way. A time when we celebrate our progress as a country. And right now, we have so much progress to be proud about. The government just announced the construction of a new full-service hospital here in New Providence, Madam President. The first in over 70 years, Madam President, before independence. The first in over 70 years. Full-service hospital here in New Providence. If you would listen, full-service hospital in New Providence, where the majority of Bahamians live. Madam President, we've laid legislation in that other place for the legalization and regulation of medicinal marijuana. We come in for our things in Grand Bahama, Madam President. TikTok is filled with videos of foreign athletes posting about the wonderful experience they've had at the World Relays. Madam President, we are on a roll. So as I rise today, I rise as a proud Bahamian and a proud supporter of this government's agenda and the direction our country is going in. Madam President, as I rise to speak in strong support of the trial by judge alone bill, I say that this proposed legislation represents a significant step forward in our judicial system, one that promises to enhance fairness, efficiency, and the delivery of justice in our courts. Trial by judge alone offers a host of benefits that cannot be overstated. First and foremost, it ensures impartiality and neutrality in the adjudication process. In a trial by jury, while we trust in the wisdom and integrity of our citizens, there is always the risk of bias, prejudice, and even misunderstandings influencing the outcome. With the judge alone, we eliminate this variable, entrusting the responsibility of decision-making to a trained legal professional who is well equipped to assess the evidence and apply the law without external influences. Moreover, trials by judge alone streamline proceedings, reducing the time and resources expended on empaneling a jury, instructing them on law, and deliberating a verdict. This efficiency not only benefits the courts, but also the parties involved, saving them from prolonged litigation and allowing for swifter resolution of legal disputes. Madam President, as you would be aware, this administration has been feverishly transforming our judicial system and the judicial process. From the administrative vantage, with legislation such as the Court Services Bill, the amendment to the Supreme Court Act, amendment to the Magistrates Act, to name a few, increasing the amount of Supreme Court judges, expanding the cases that the magistrates can hear, and streamlining processes throughout the judicial system. We've also tinkered with the judicial process with bills such as the amendment to the Bail Act, which for the first time strengthens our processes on granting bail. We've passed anti-gang legislation, a tough crime measure providing for serious offenses for gang activity. Madam President, as you can see, we are tackling crime and the advancement and modernization of our legal system from all angles, making the court system and the court process more robust and more fair. Madam President, this bill before us is but yet another angle we are tackling these issues from. And perhaps most importantly, trials by judge alone have been proven to ensure justice is served. Across the globe, numerous jurisdictions have successfully implemented this system, yielding positive outcomes and reinforcing public confidence in the legal system. Let's take a moment to look at some of the success stories from around the world. In Canada, Madam President, trials by judge alone have been utilized in certain cases, particularly involving complex legal issues or sensitive matters where impartiality is paramount. We can think of numerous cases in our court system right now involving complex legal issues or sensitive matters where impartiality is paramount. This approach has been praised for its effectiveness in delivering fair and just outcomes while maintaining the integrity of the judicial process. Similarly, in Australia, trials by judge alone have been embraced as a means of addressing concerns about jury bias and ensuring a fair trial for all parties involved. The flexibility of this approach has allowed courts to adapt to changing legal landscapes and evolving societal norms, ensuring that justice is accessible and equitable for all. In the United Kingdom, trials by judge alone have been instrumental in enhancing the efficiency of the legal system, particularly in cases involving national security or organized crime. By entrusting decision-making to experienced judges, the UK has been able to expedite proceedings and address complex legal issues with precision and clarity. Madam President, this is the direction we want to go in. And these examples serve as compelling evidence of the benefits of trials by judge alone. They underscore the importance of modernizing our legal system to meet the demands of the 21st century while upholding the principles of fairness, impartiality, and justice. In 2020, during the height of the COVID pandemic and the increase in COVID-related offenses, charges, and trials, this very topic of trial by judge alone was a hot topic in legal circles in the UK, Canada, and New Zealand. Laura Hoyano, a seasoned criminal silk and former High Court judge in the UK, wrote a defining opinion article in which she challenged the immediate dismissal of trials by judge alone as detrimental to justice, citing their successful operation in Canada, where she also practiced. With reference to the UK, she asserted that the opposition to trial by judge alone was hasty and underestimates the effectiveness of those trials, which have been functioning smoothly in Canada, New Zealand, and certain Australian states for decades. She heavily highlighted Canada, where criminal justice was underpinned by a robust defense rights mechanism and judicial independence guaranteed by the Canadian Charter of Rights. While trial by jury is the default in Canada, defendants have always been able to have the right to elect trial by judge alone, ensuring comprehensive and impartial examination of the case. Madam President, our most capable Attorney General has gone through the minutiae of the bill. Therefore, I won't rehash the finer details. Rather, I will comb through what I consider some salient points that Bahamian people broadly should be aware of. The essence of this bill lies in providing an alternative mode of trial for individuals committed to stand trial in the Supreme Court on indictment. It grants accused persons the right to waive their traditional trial by jury and opt for trial by judge alone. Madam President, this is an option for the defense. Importantly, this choice can only be made after the accused has received legal advice and knowingly waived their right to it, ensuring informed decision-making. Furthermore, this bill sets forth stringent criteria for the waiver of legal advice. It mandates that a judge may only order a trial by jury alone if satisfied that the accused is competent to make such an election. The jurisdiction of the judge in a judge alone trial, Madam President, is clearly defined under this legislation. Judges presiding over such trials are empowered to adjudicate on both the law and the facts, ensuring a comprehensive and impartial examination of the case. Moreover, the bill ensures consistency in legal terminology by stipulating that all references to trial by jury in existing laws shall encompass trial by judge alone when elected by the accused. This harmonization of language simplifies legal proceedings and eliminates ambiguity in interpretation. Finally, Madam President, the bill includes consequential amendments to various existing laws, ensuring coherence and compatibility with the new provisions. Madam President, the enactment of legislation for trials by judge alone is imperative for enhancing efficiency, fairness, integrity of our judicial system. It also assists in timely trials occurring and provides a new tool in the arsenal of the defendant by empowering the defendant to make informed choices and ensures that justice is served swiftly and impartially. Madam President, we are tough on crime and we are committed to improving our judicial system. So as the sun comes in, Madam President, and we all beam with a little bit more pride of being Bahamians, Bahamians can also beam with pride because their government is hard at work in every facet of the economy. From healthcare, to transportation, to investment, to trade, to crime, and the judicial system, we are hard at work, Madam President. And so with this brief contribution, I urge all members of this body to support the bill before us. Let us seize this opportunity to enhance the integrity, efficiency, and effectiveness of our judicial system, ensuring that justice is not only done, but seen to be done. Thank you, Madam President.
Thank you, Senator the Honorable Barry Griffin.
Picture I seen in the bill this morning.
It has been moved.
You on Facebook?
It has been moved and seconded that the following bill be read for a second time and committed. A bill for an act to grant a right of election to persons charged with indictable offenses in the Supreme Court to be tried by judge alone, and for the consequential amendment of miscellaneous provisions of law and for connected purposes. As many, the chair recognizes Senator the Honorable Michael Bonnet Ellis.
Thank you, Madam President. Madam President, it's good to have you back in the chair. Nobody quite does it the way you do. Madam President, with your permission, before I start, I would like to welcome to our beautiful aquamarine shores the men of Phi Beta Sigma Fraternity Incorporated. They have chosen our beautiful Bahamas to host their Southern Regional Conference. So to Brother Dr. Emmerich Farmer, the Regional Director, and the over 500 Sigma men and their guests that are registered to attend this conference, I say to them in my tourism voice, welcome to the islands of the Bahamas. And most importantly, I have to say to them that once is not enough to see all of we stuff. And so they must come back so that they can enjoy more of the wonderful recreational activities that we have in Nassau and on our family islands. Madam President, it is no secret that there is a demand for accessible, positive male role models worldwide. And so we must support organizations like the fraternities that make up the Divine Nine, because they bring together men at an undergraduate and graduate level with a passion for education and service, men that appreciate the need to support each other and build each other up. If there's any question about the caliber of men that belong to these organizations, we don't have to look very far, because in this honorable chamber, we have 3 men that are members of Divine Nine fraternities. Senator Halkitis is a member of Omega Psi Phi Fraternity Incorporated, and Senators Randy Roll and Quentin Lightbourne are members of Kappa Alpha Psi Fraternity Incorporated. Now, none of them are privileged enough to be my constitutionally bound brothers of Phi Beta Sigma, but they are good men. Madam President, we are, you know what, they don't like anything I say. We are debating a compendium of draft legislation that deals with the administration of justice in our Supreme Court. The criminal side of our Supreme Court is a unique creature. This is the side of the court in which life and liberty are at stake. The criminal side of the court, more so than the civil side, is under-resourced and oversubscribed. The legacy issues that plague the administration of the criminal side have contributed to our rising violent crime statistics. Lack of justice in our judicial system has led to retributive justice on the streets. Delays in trial have meant that defendants remain on bail for years. Procedural applications in the middle of trials lead to lengthy trials, and tales of which would discourage anybody from serving on a jury. Reforming our criminal justice system will not singularly reduce crime, but must be part of that holistic approach to improve the administration of justice and inspire confidence in the criminal justice system. These pieces of legislation allow for 2 things. 1, giving defendants the option to be tried by judges instead of a jury, and 2, to particularize the authority for creating criminal and civil case management rules. My colleague, Senator Pickstock, when we were debating the anti-gang compendium, argued that we must not be lawyers in this place. Madam President, I respectfully disagree. We have a constitutional duty to make laws for the good government and peace of this country. And as lawyers, professionals in the law, we have the benefit of knowing when draft legislation is unlawful or contrary to the interests of justice. Just as a unionist at this table would not divorce themselves from their background and support union-busting legislation. Criminal trials determine a person's liberty and in certain circumstances can determine their life. The right to life and the right to liberty are universally accepted fundamental human rights. These rights should not be deprived or infringed capriciously. Did you know that most trials in this country are actually not tried by a jury, but are tried by a judge or a magistrate? Civil trials in the Magistrates Court and the Supreme Court are all heard by a judge. A judge issues a written, reasoned decision, and she discusses and weighs the facts and applies them to the relevant law. In criminal trials in the Magistrates Court, where liberty is often at stake, there is no jury. Those trials are heard before a magistrate, and the magistrates issues written, reasoned decisions. She discusses and weighs the facts and applies them to the relevant law. In the industrial tribunal, the same thing. The trials are heard by a tribunal, and the tribunal issues written, reasoned decisions. In criminal trials in the Supreme Court, where not only liberty is at stake, but a defendant's life may also be up for determination. The matter is tried by a jury of their peers that determine their guilt or innocent, jail or no jail, death penalty or no death penalty, without even having to utter a word about why they decided the way they did. We'll never know which witness they found to be credible. We'll never know whether the DNA evidence was compelling. We will never know if they believe the police officer's account or not. It is a fundamental component to fairness that an authority must give reasons for their decision. In fact, the failure to give reasons is a ground for judicial review of a decision, just as the failure to give reasons when terminating someone without notice is a reason to find that dismissal unfair. Criminal trials in the Supreme Court make up less than 5% of the trials heard by our justice system. And while there are many reasons why a trial by a judge is beneficial, there is one concern that outweighs all of the benefits for me. We have been plagued with lengthy delays between trial and receiving rulings from the court. Too many attorneys can tell stories about waiting over a year for a written decision in their matter. Courts have heavy calendars, and many sit 5 days a week from 9:30 to 4 or 5 with just a lunch break. Ideally, they have writing days to decide decisions, but the realities of the justice system is that it is bursting at the seams, and writing days are rarely possible because attorneys are begging for court fixtures. Before a judge can write a decision, there need to be transcripts. Successive chief justices and attorney generals have tried to implement electronic court recording system. But the truth is, there's no substitute for an in-person court reporter, and we simply do not have enough of them. Court reporters are a critical component to the judicial system. And so I say to high school students looking for a career or undecided college students, consider training to be a court reporter. You will be in demand in the public and the private sector. And I don't want to encourage you to leave, but it's a skill that can be used in more than one jurisdiction. But I digress. But it has been my experience that the court recording system simply doesn't work as planned. And if their system is working, there's a delay as we wait for the audio recording to be transcribed by a stenographer. And we just hope that the microphone picked up every word. Our judges are working very hard to spin gold out of straw. And do we really want to add another task as important to writing written decisions in criminal trials without giving them more resources to address the existing burdens? The amendment to the Supreme Court Act particularizes the authority of the court to make rules for case management of criminal and civil trials. This amendment may seem pedantic as the chapeau of Section 76 already refers to creating rules for civil and criminal matters. And the subsections under it specifically list the matters that rules can be created for, but do not specifically list case management. I don't intend to weigh in on the need for the amendment because we've already far too many times passed amendments that have been unnecessary. The amendment to the Coroner's Act immediately comes to mind. But the AG has spoke excessively about the draft criminal procedure rules and hoped to receive concurrence from this side. It would have been great if we'd seen the rules, and if they had been shared, we could have concurred. They say that they are interested in collaborating, or really seeking our concurrence. But this isn't a contentious issue. Robust criminal procedure rules are necessary. Criminal matters, directions in criminal matters are a relatively new development. We join countries like Trinidad and the Eastern Caribbean Court that have all recently instituted extensive criminal procedure rules. And I'm almost tired of repeating and reminding in this place that this administration promised good governments, and that includes more than just PR, but requires transparency, consultation, and accountability. Case management rules are essential to the efficiency and fairness of our court's process, and we must, out of an abundance of caution, make sure that the authority for those rules is well established. The amendments and the draft bill are not novel or outstanding. The law is a living, breathing creature that requires a tune-up or update regularly. We must make sure that our legislation keeps with the development of law and legal principles in the region and in other common law jurisdictions. Antigua passed this week permanent legislation allowing judge-only trials. They initially passed this legislation during the pandemic, and it was meant to remain in force for 2 years. But it's worked so well that they have extended it twice, and now they seek to make it permanent. We must resist this government's pleas for accolades for doing the work that they were elected to do. Have we dropped the bar so low? When I was a student, I didn't get an allowance. And when I garnered the courage to ask why I didn't get an allowance like other people did, my dad turned his head to the side, and that's the number one sign that he was about to, school me on something. And he said, "Why should I pay you to do the things that you are supposed to do? You are supposed to do chores. This work that the government is doing, this is the work that they're supposed to do." And so now, if they only start answering the questions about how they're spending our money.
So you're saying we're doing what we're supposed to do?
Thank you.
And seeking accolades for it.
Great job. Thank you.
Not doing.
Thank you.
Let me finish that last sentence. Now, if they would only start answering the questions about how they are spending our money.
Are you not present during budget debate?
As I close, we are approaching the great feast of Pentecost. And so I want to say congratulations to all of the young people that are being confirmed in the Catholic Church this weekend. Christians considered Pentecost to be the birth of the Christian Church. And no doubt many Bahamians, like me, are looking forward to a long weekend with friends and family. But I challenge us to think about the message that we spread. The Holy Spirit empowered disciples to spread the gospel of Jesus. Who is empowering us? And what are the messages that we are spreading on their behalf? Is it a message of positivity, unity, and community and empowerment? Or is it a message of division and destruction? We need to go back to looking after our village, because it not only takes a village to raise a child, but it takes a village to move our great country forward, upward, onward, and together. Madam President, as always, may God bless you. And I pray that he continues to bless our Commonwealth of the Bahamas.
Thank you, Senator the Honorable Michael Barnett Ellis, for your contribution. As many, the chair recognizes Senator the Honorable Darren Pickstock. The chair recognizes Senator the Honorable Darren Pickstock. You have the floor.
Good morning, Madam President, and I welcome you back to the chair. I also welcome my brother Barry as well back in the House, in the Senate. And I would also like to wish him a happy birthday. So happy birthday to my brother. Madam President, before I before I delve into my contribution today, Madam President, I would like to join the nation and my colleagues and others in that other place in paying respects to the late Loftus Roca, a Loftus Roca, a national hero of the highest order. Madam President, Mr. Roca hailed from the island of Auckland, the same birthplace and roots of my mother and her extended family. Mr. Roca was unique. Although he was born and raised in Delectable Bay, that wonderful place, along with many other Auckland's men, and the first time he ever ran for public office on election to the House of Assembly, it was for the Auckland seat in the 1965 general election. He would eventually get elected to the constituency of Nicholstown in North Andros, a community and district from which my father's family has its roots. Mr. Roca, like many of the great stalwarts and nation builders of the post-World War II era in the Bahamas and the Burma Road Riot, leaves a legacy which is perhaps best embodied in the title a former distinguished president of this upper house, Boris L. Johnson, called the Quiet Revolution. Mr. Roca and the gallant men and women of the day led the charge which transformed minority governance of the colony of the Bahamas Islands to majority rule on January 10, 1967, marking a watershed moment in our nation's history. And he didn't stop there. Madam President, revolutions, we are told, never turn backwards. And on July 10, 1973, Mr. Roca, a signatory to the Independence Instrument in London, participated in the birth of the Commonwealth of the Bahamas. Mr. Roca served in many cabinet portfolios as a Minister of Health and Housing, as a Minister of National Security and Immigration, as a Minister of Works in economic uncertainties of that OPEC crisis and recession and the tumbling of the US dollar. He oversaw how capital works were done in this country and remain on pace. He led through the potable water crisis in Nassau and the barging of water from North Andros. He was unceremoniously dubbed Surcharge by the political cartoonists of the area when he had to introduce a fuel surcharge onto electricity bills at a time of heightened OPEC-induced fuel or energy turmoil. He remained a PLP conservative and was not afraid within his own organization to speak truth to power. As a stalwart of the Progressive Liberal Party, Mr. Roca embodied integrity, fearlessly advocating for transparency and accountability within his own ranks. At an open public PLP convention, he warned his beloved leader and Prime Minister Lyndon Pindling about the lurking damages of public corruption by officials. He called for honesty and transparency, which is a testament to his unwavering commitment to the public good. As Minister of National Security and Immigration, his hardline approach on immigration and drug trafficking reflected his unwavering resolve to uphold the rule of law by his compassionate legal eagle, but as a compassionate legal eagle, he demanded and required that every alleged illegal immigrant be brought before a court for such a determination to be made according to the law, before any deportation could take place. As Minister of National Security, in the ugliest of the drug trafficking period in Latin America, where the Bahamas became a major transshipment point for the narcotics entering the United States, Mr. Roca, unyielding in his discourse and his firm commitment to bringing the guilty to justice. Madam President, it would be Mr. Roca who moved an historic resolution in Parliament which denies any person charged and convicted of drug trafficking or benefiting from the proceeds of such to be seated in the lower house. In the historic 1987 general election, Mr. Roca retired from frontline politics. His remaining years were spent as a statesman and guardian of welfare, his legacy immortalized in the dedication of a school named in his honor on his beloved Acklins Island. Madam President, as we bid farewell to this titan of Bahamian history, may his soul find eternal peace, his legacy enduring as a testament to the indelible mark he left upon our nation. Rest peacefully, Mr. Roca. Thank you. Madam President, you know, I every time I get up in this place, I'm grateful for the opportunity to serve my country. But today I will try and lay off responding to my learned colleague on the other side, and I will go straight into my contribution in this honorable place. Madam President, today, the bill before us today, Madam President, marks a significant milestone in the evolution of our criminal jurisprudence in the Bahamas. Madam President, the essence of this bill lies in providing accused individual with the option to elect for a trial by judge alone rather than by jury. While by jury has been a cornerstone of our justice system, this bill recognizes that circumstances may arise where a trial by judge alone is more appropriate or desirable for the accused. Madam President, and surely we do recognize that there are trials by juries that already exist in our system, Madam President. But Madam President, the government of the day seeks, Madam President, to give an option whether one would be tried by a judge alone or by a jury. Madam President, to achieve this endeavor, the bill before us makes amendments to several key acts: the Court of Appeal Act, the Supreme Court Act, the Magistrates Court Act, the Penal Code, the Criminal Procedure Code, the Capital Punishment Act, and the Child Protections Act, and the Firearms Act. Again, Madam President, I would like to take this opportunity to thank the learned Attorney General and his team for their dedication to the government's legislative agenda. The AG has again provided thorough insight, very comprehensive, on the bill today, and he and his team must be recognized for their gallant effort, Madam President. The question that, of course, will linger will be if and in what extraordinary course of time trial by jury may be eliminated in our system. That is indeed the question, Madam President. It is a debate for future generations in this chamber to grapple with. Madam President, the distinguished jurist Sir Burton Hall, a former Chief Justice of this country and now a judge of the United Nations Residual Mechanisms for Criminal Tribunals, in a presentation almost 7 years ago, advocated exploring alternatives to jury systems, particularly for criminal trials in the Bahamas being heard before a single judge or justice of the Supreme Court, rather than under the jury system. The debate which began on Sir Burton Hall's advice brings us to this place. Recently, while in Nassau, Sir Burton again at a distinguished lecture with his judicial brethren offered new scope on how we may wish to further amend or give new impetus to criminal trials in the Bahamas and improve our system. Legal scholars, I'm certain, will use these discussions and works to keep the debate sensible and relevant to the Bahamas and the Bahamian people. Under the proposed legislation, Madam President, before us, an indicted person seeking to be tried by a single judge rather than a jury is required to demonstrate their understanding of this choice, whether with legal assistance or without. Given the complexity of legal proceedings, ensuring defendants fully comprehend their decisions is paramount. Here, in a country where we take 2 weeks to count and recount the Junkanoo tallies and scores, it is a fair assumption that even those who elect to be tried by a single judge of the Supreme Court may find a ground of appeal in the argument of their understanding of their choice. While some may view this option with skepticism, clearly, as we heard from my learned colleague, Senator Michael Barnard Ellis, Madam President, there are countries which may admire where trials by a single judge are commonplace. My colleague, Senator Barry Griffin, clearly outlined various examples around the world where this is commonplace. Madam President, like most Bahamians, I am eager to see this process played out. And given the ordinary process of first trial to court of appeal, stage, or higher appeal, in the case of capital offenses, time will have to give us the answers. Madam President, the long and short of this legislation is that prosecution still has to present a winnable case, and that the defense must have its convincing day in court. That is the long and short. The test for us in the Bahamas may be in how single judges hearing such cases are able to wear both hats, judges of the facts and not just the final say on the law. But once again, these are decisions that accused persons must make as to how they wish to prove their innocence or ensure that their rights as accused persons is not sullied or damaged or harpooned by overzealous investigators, Madam President. Madam President, there is another concern here in that in a recent matter before the High Court, a criminal trial was closed and a jury dismissed because of a claim that a juror may have a relationship with an outsider of a political nature, which may lead to a prejudice against the politician on trial. It must therefore now stand, Madam President, to be examined in trials by single judges rather than by jury. Will a judge have to face similar invasive procedures? And in such cases, how will it be determined as to the scale of a relationship can or may be seen as impactful or prejudicial? Madam President, I must support this legislation. And in conclusion, this bill represents, Madam President, a bold, innovative step towards enhancing our criminal justice system by providing defendants with the option of trial by a single judge. Madam President, I'd like to just outline very briefly the benefits, if I can, of both for the judicial system and for the individuals involved in legal proceedings. Madam President, when we look at some of the benefits, we look at the efficiency aspect, Madam President. Trials by judge alone often proceeds more quickly than trials by jury. Without the need to impanel and instruct a jury, the trial process can be streamlined, reducing the time and resources required for legal proceedings. Cost effectiveness, Madam President. Trials by judge alone can be more cost effective than a trial by jury. They typically involve fewer logistical complexities and expenses associated with jury selection. Expertise and experience. Judges are legal experts with significant experience in evaluating evidence, applying the law, and making impartial decisions. Madam President, consistency, privacy and confidentiality, the reduced risk of mistrials, Madam President, and flexibility. Overall, trials by judge alone offers a pragmatic alternative to trial by jury in certain circumstances, providing a fair, efficient, and reliable mechanism for adjudicating legal proceedings. Madam President, we signal by this legislation our commitment to a fair and transparent legal process. Thank you, Madam President. Again, I support this bill.
Thank you, Senator the Honorable Darren Pickstock, for your contribution. As many, the chair recognizes Senator the Honorable Darren Henfield.
Thank you, Madam President. I join in with the chorus of others who welcome you back to your rightful space, and to say that when you're gone, we miss you. I'd also like to, it's recorded. I'd also like to, with your permission, adopt all of the words spoken by Senator Pickstock, my namesake, relative to the Honorable A. Loftus Roca, whom we lost, and I'm happy to have heard by leader of government business in this place that we will have a time to properly say our farewell in this place to a great Bahamian who served us well, one of our founding fathers. And I think during the last independence celebrations, a new generation may have come to know who Loftus Roca really was. A new generation of Bahamians. He was a personal friend of my father's. In fact, my father was his campaign general when he won. When he won in Nicholstown. And so we had a very good discussion. We had a very good discussion about it. We had a very good discussion about it just this week, about his time with Mr. Roca and what that meant for their friendship and for what they did, what they were able to do in the country. I'd also like to commend, Madam President, to commend the volunteer fire services in Abaco, who have been for the last several weeks on the wall and fighting wildfires. They assure me that they will continue to work hard and fight, and that they've not lost anything of significance during all this time, and so to God be the glory. And we pray his continued favor upon us in this regard. But I'd also like to say to some of the young men in our communities, not only in Abaco but all across this country, that volunteer firefighting is very much needed, and there's not just one segment of our community that ought to be seen doing it. We should all find a way to pitch in and support the firefighters. I'm told by the firefighters in Abaco that they are prepared to train young men from our various communities to come and learn the art of firefighting, so that when the fire comes to your community, when the engine shows up, you're able to hold a fire hose, or you're able to hook up that hose to a hydrant and help fight the fire to save our communities. I'd also like to send condolences to the family of Lauristain Evelyn Fox of Sandy Point. She's going to be eulogized on Saturday, on the 18th of May, at the Assemblies of God Church in Sandy Point. She was a good, strong Abaco woman, and a good, strong supporter of the Free National Movement. And so we hope to be fully represented at her funeral. The AG, Madam President, went through an impressive list of his legislative work thus far, and told us that he has much more to do. And when I hear that, I often wonder, it is okay to come here and pass a bunch of legislation and do a lot of work, but how is it impacting us on the ground? That's the key for good legislative work. It should be manifested on the ground in a way that tangibly Bahamians can feel what you are doing. The Ombudsman Act, for one, we don't know what's going on with that, where that is. That will too serve to help alleviate pressures from the courts when you're able to go to an ombudsman and have your disputes settled. Alternatively, outside of a courtroom. And so I'm very pleased to say we support the bills before us today on this side. And you mentioned the anti-gang bill, and we just saw recently where a young man in his bed sleeping with his 10-year-old brother was shot through a window. And so until we start to address these very important social issues with our legislation in a way that we want to tangibly, we still soldier on. So we're not going to be like George Bush, who flew in on an aircraft carrier and said, wave the flag and say he's done it. Mission accomplished. That's what he said, right? Mission accomplished, and then you went on years and years and years, and with the war raging and ongoing. And so we are in fact in a war that is raging and ongoing, and we collectively have to find a way to deal with it. So today we debate the Supreme Court Amendment Bill 2024 and the Trial by Judge Alone Miscellaneous Provisions Bill 2024, the latter being the one upon which we be most focused, albeit very, very briefly, because the bill is self-explained and very straightforward. The Trial Judge Alone Bill provides in Clause 4 that an accused person committed for trial to the Supreme Court on information, or an accused person charged before a magistrate's court with an indictable offense against whom a voluntary bill of indictment is proffered by the Attorney General's office, is subject to the provisions of the Act, be tried by a jury unless he elects to be tried by a judge alone. Now, Article 20, 2G, Article 20, subsection 2, subparagraph G of our Constitution guarantees the right to be tried by a jury when charged on information in the Supreme Court. So this bill, in fact, asks an individual to waive a deeply entrenched constitutional right, and I believe only the Bahamas and Bermuda has the level of entrenchment on this particular law. This is an entrenched right which can only be removed by a constitutional referendum. Governments in the Bahamas don't do referendums. Governments in the Bahamas don't really like to do referendums anymore, because they find that when you do the referenda, trouble follows. But I heard Sir Burton's name called in this place a couple times, and during the 2013 review of the Bahamas' constitution, the Commission examined the question of whether the right to trial by jury in certain cases could be done away with. And Sir Burton presented, along with several others, to the Commission. The Commission was led, of course, by King's Counsel Sean McQueenie, a well-established jurist, a legal mind in the country. And so some presenters, including the former Chief Justice Burton Hall and the Attorney General, then the Honorable Alison Maynard Gibson, argued in favor of the disentrenchment of the right to a trial by jury. So they thought this is something that we should have been looking at many years ago, because of obvious reasons. The cost of jury trials the difficulty in assembling a jury. Recently, where some employer, Madam President, said to someone who was on a jury that your pay might be cut. Yeah, and the judge rightly called them in, and that was good for the judicial system in the Bahamas, to send a message to all other employees that jury duty is a responsibility that they too must share in, you know, and so there are so many disadvantages of having a jury. And so Sir Burton thought that the jury trials were sometimes, and I'll try to quote him here, inefficient. He said, prodigal on resources, but wasteful on resources, right? And ultimately unfair. At the time, there was not, there was no unanimous support for the abolition of jury trials, as a position was felt that it wasn't widely supported within the ranks of the then judiciary. Today, I venture to say that that view has changed. I recently had an occasion to speak with two very senior jurists at a function, and both agree that this is the way to go, and they were happy to see this bill being enacted into law. My view was, and I shared it with them, was that I don't know that many people will opt for a judge-alone trial, but there are pros and cons which we talked about. If you're in an extremely technical matter where the mind of a judge could be placed to the evidence and the facts, and look at a lot of technical aspects which sometimes are lost on juries, it might be beneficial for you to do so. Deep commercial matters, or you know, it might be beneficial to have a judge alone look at it. And so, all told, it was never felt that removing the constitutional right to trial by jury would lend to unfairness or bias. And so we don't believe that if you go before a judge alone, you're going to be treated unfairly or treated with some bias. On the converse, it may be so that a jury looks at you and say, I find this particular fellow here, you know, quite odious. It could be the mannerism in which you sit, you know, look on your face, right? It could be the mannerism in which you look at a particular juror who looks at you and says, you know, the old people used to say, there's something about him. I can't explain. I can't quite put my hand on what it is. My spirit don't take to him, right? my spirit don't take to it, right? And so, but Madam President, we must point out, however, for the benefit of all, that the right to trial by jury emanated from the Magna Carta, and guaranteed courts would depend on a group of citizens taken from among us who perhaps had similar life experiences. And so the rationale was that no free man may suffer punishment without the lawful judgment of his peers. You know, and so these juries, they bring all of their experiences in the community, all of their education, all of their professionalism, and they bring them to bear on what we do in the courts. They're drawn from across our communities, and they come from all walks of life and bring with them their various and varied experiences. Unlike judges, juries are not required, as we've heard here already, they're not required to give reasons for their verdicts. And so Clause 7 of the bill requires that a judge to render in writing a judgment stating the reasons for his verdict at the time of conviction. We all hear about sometimes how difficult it is to get the verdicts or to get the decisions. Sometimes it takes a bit too long. I don't lay all of that at the feet of the judges, because there are things in the system that we perhaps need to look at fixing to help them to be more judicious in the way that they render their written rulings. So Clause 7.6 provides that where a judge fails to deliver his judgment or give reasons for an acquittal within a period specified in subsection 5, he shall convene the court and inform the parties of the time that he requires to come. So this law literally places upon a judge the responsibility of coming back and saying to me, I'm going to need more time to complete my decision or my written ruling on your case. And this is the time that it's going to take me. And so it puts more of a responsibility on the court and time frame and measurement in which to be judicious in the way that it carries out its responsibility. And so that's not a bad thing. Although we support this effort to move the system more readily along, we know that there remains much more work to be done if the justice system is to function as we would all wish it to function in our small country. We still await the establishment of the long promised, and we heard the AG talk about them today, specialty courts, such as the juvenile court, the family court, the sexual offense court, and the commercial court. These will all cause our judicial system to be freed up of certain things so that people can focus within their disciplines to get these rulings and judgments out and make more courts available to our people at a time when God knows it seems we need them, and we should be needing them less. So in that same vein, if we're going to have a properly functioning judiciary, more must be done. Last year we passed the long-awaited Court Services Act, and among the objectives of the legislation was to enable the judiciary to fulfill its constitutional role of dispensing justice. It was hoped that the act would give the judiciary adequate financial resources, and we hope to hear about that in the upcoming budget, how we're going to outlay funding to cost these courts and even this place, the Parliament, to be able to function in the way that we want them to function, because we realize the separation of powers is important, and we've done these laws so that we can actually have independence in the way they function. And so they need the resources. They need competent staff. You find a justice in the United States, man. They got a slew of staff helping them to do research, helping them to write and put together their judgments. And so with those few words, Madam President, I thank you for the time, and I rest. You want this? No problem, I got you. Mauricio wants to speak.
The chair recognizes Senator the Honorable Dr. Eresia Hepburn Forbes.
Madam President, I join in with my colleagues in this and other place in paying condolences to a true statesman and patriot that feared no one when it came to standing up for our beautiful archipelago, Mr. Roca. I would also like to go on record to wish the Vice President of the Senate a very happy birthday, and may God grant him many, many more. And I apologize for the Bahamians that are numbers people. He won't give us the number for me to give it to you. Madam President, today is another opportunity to discuss a significant piece of legislation that has the potential to reshape our judicial system. This bill is not just a piece of legislation, but a reflection of our commitment to justice, fairness, and the rule of law. It gives persons an opportunity to waive their constitutional right to a jury trial in favor of having a judge rule based on findings related to the facts and the relevant law. So to all Bahamian citizens, the question that you want to know is whether this bill is a good idea. So let's think about that. It is important to note that this bill introduces an additional right, the right to choose a trial by judge alone. It does not take away a right, but provide you with an additional one. This is a change that legal scholars and professionals have been requesting for some time, according to basic research done. It does not, again, take away the right of a jury trial, but adds another option for the accused. Madam President, while there are several senior learned persons around this table, I can recall this topic being one of my questions for my LLB classes. And for the research done there, I know that this discussion has been in the legal field for some time. What I found then and now is that the general thoughts on this concept have been largely positive. Particularly in the Bahamas, current and former Chief Justices have called for more bench trials, and this Davis administration has tabled the bill in response. This is a significant change to our judicial system, and it is crucial to ensure the rights of the accused are fully protected. And we are doing so, again, by providing them with additional rights. Madam President, while our esteemed Prime Minister still affords me the honor to serve in this upper house, I will do my best to ensure that I express clearly and concisely to the general public any piece of legislation we introduce to the best of my ability. The introduction of judge-alone trials could potentially have several effects on jury trials. So, to the public, what are the benefits? A reduced burden on jurors. As more accused persons opt for judge-alone trials, the demand for jurors could decrease. This could decrease the burden on citizens who are called for jury duty. And while one may argue we could find a workaround, you pay more for persons to be on jury duty, we could only get people from the unemployed list or retired persons, this bill still gives you another option. Expedite judicial processes. Judge-alone trials could be quicker than jury trials as they eliminate the need for the jury selection and instructions and deliberations. A potential for increased acquittals was found globally. A study found that judge-alone trials were associated with a 12% point increase in the probability of acquittals, and that's after controlling for characteristics and effects of many of the outcomes. For some of the lawyers, this would mean a change in legal strategy. Defense attorneys may need to adjust their strategies based on whether a trial is jury or judge alone. Arguments that might appeal to jury's emotions, which has always been a bane of some existence, may not have the same effect on the judge, who is trained to apply the law objectively. Well, Madam President, we all know that there are always two sides, at least to every story. So while trial by judge alone bill has its merits, it's important to consider potential drawbacks as well. I will present research for both sides and still showcase why this is a great option for us Bahamians. Madam President, Lord Delvin stated, the first object of any tyrant would be to make Parliament utterly subservient for his will, and next to overthrow or diminish trial by jury, for no tyrant could afford to leave a subject's freedom in the hands of his 12 countrymen. So, what are some of the negatives according to this? Loss of public accountability. Jury trials involve ordinary citizens in the judicial process, which can enhance the public's trust in the system. Shifting to judge-alone trials could potentially reduce the sense of public accountability. However, we do not take away this benefit, so this, again, could not factor in. I heard in the other house, however, potential bias may be an issue when it comes to this. Despite judges' efforts to be impartial, they may bring their own biases when making decisions, and I'm ad-libbing, it was not said that verbatim. However, a single judge may have limited range in perspective. Well, you could always introduce a diverse panel. Some also say a risk of intimidation or threat. In some cases, the accused may prefer a jury trial because they may feel intimidated by the judge, or complexity of the trial. Some trials are complex and require collective wisdom of a jury or panel of judges to reach a fair verdict. However, even with these opposition, let us be clear, we are not taking away the benefits of trial by jury, just providing another option for you, the Bahamian people. Madam President, let's take a deeper dive into addressing the potential bias of judge-alone trials that was brought up in that other place. We know this is a complex issue that many countries grapple with. So here are some of the strategies that have been employed globally that we can enshrine and to ensure that this doesn't happen for us. If there seems to be bias, we can increase education and training, where judges undergo training to help them recognize and mitigate their own biases. We can introduce a judging panel. So instead of there just being one judge, we have 3. Some countries have put the system in place where a panel of 3 judges for trial alone by judge. Having a diversity in the judiciary is another option. The use of artificial intelligence is something some countries are exploring, and continuous research and analysis of ongoing judge-alone trials to help identify any patterns of bias. These are simple tools that we could implement so we could ensure that no one is disenfranchised. It is important to note these strategies are not foolproof, but we are committed to continue researching and innovation in this area to ensure the fairness and integrity of the justice system. Madam President, there are similar bills in other countries that allow defendants to choose a trial by judge alone. In the United States, the United Kingdom, India, Canada, Netherlands, and closer to home, Trinidad and Tobago. These countries have recognized the potential benefits of judge-alone trials, such as reducing the backlog of cases as stated by our AG, expediting the judicial process, and specific provisions in implementations in these countries have been beneficial all around. While there may not be specific international guidelines, trial by judge alone, there are general principles. These principles include fairness, which our own have. The process is fair and impartial. Transparency, which we have. Efficiency. Legislation should aim to improve the efficiency of the judicial system, which we claim to do. Accessibility. You have the right to choose between a jury trial and a judge-alone trial. Those 4 tenets are implemented globally in all of those countries, and we are implementing them here. So, Madam President, this bill does nothing more than empower our citizens with more options. It is a benefit. This legislation is well-informed and meets the needs of the justice system. For a trial by judge alone, the judge would have the power, authority, and jurisdiction what he or she would have in a trial by jury. This includes the power to determine any questions and make any findings which would have been required to be determined or made by the jury. Madam President, I will make this clear one more time to the Bahamian people. The trial by judge alone bill does not eliminate jury trials, but adds another option for the accused. It could potentially expedite the judicial process. We've heard it from everyone who got up and speak on this bill about the backlog. We are trying to resolve issues that you bring to us, Bahamian people. Reduce the burden on jurors. If we be honest, most people don't want to serve on jury duty. So we're helping you here. Now there are other options and lead to changes in legal strategies. We are fully aware that it's important to monitor these changes to ensure that the rights of the accused are fully protected and justice is served. And we in the Progressive Liberal Party ensure that we do that. We come back with new legislation. You heard from those opposed. We are doing our job, and we should be rewarded for doing our job. Madam President, in summary, the trial by judge alone bill is a progressive step towards reforming our justice system. It aims, again, to expedite the judicial process, ensure swift justice, and provide an additional right to the accused. As we conclude the debate on this bill, let us remember our commitment to justice, fairness, and the rule of law. Madam President, with that, I support this bill, and may God bless us in this honorable House, and may God bless the Commonwealth of the Bahamas.
Thank you for your contribution, Senator the Honorable Dr. Eresia Hepburn Forbes. It has been moved and seconded that the following bill be read a second time.
I gotta wrap up.
As many? Sorry.
I'm good. I'm good. I want to thank Madam President for allowing me just a couple of minutes before we conclude. I want to thank my colleagues, and I thank you for your contribution. It's very on point. And my colleagues on the other side, although I'm not quite sure yet whether they're voting for or against. We will stay tuned on that one. But just briefly, my good friend and colleague, Senator Barnett, made a point about judges having to wait on transcripts and judges having to write decisions with respect to judge-alone matters. And I just want to enlighten her on how I see this conducting. With respect to the issue on criminal justices having time to write a decision at the end of trials, judges get transcripts of the evidence and issues raised at the end of each trial day. There does not have to be a lengthy ruling on the decision at the end of the trial. We envision a short ruling, page, 2 page, 3 pages, with respect to a criminal matter, where the judge accepts the evidence and gives reasons on why they accept the evidence, and the decision that she comes to with having regard to the facts and the law on the matter. During the trial, a judge will have given rulings on voir dire, on issues of admissibility, and other things throughout the trial that will be a basis for the evidence in which that judge accepts and doesn't accept at the end of the trial, which together with the decision on guilt or innocence will form the ruling for the purposes of appeal, if any. This is how we see it unfolding. I'm not sure it is necessary to have, as some judges write, 100+ pages in their rulings for a criminal matter. That's just how we see it going. So I think that the alarm raised is a false alarm, and we will treat it as such. Having said that, I so move for the second reading of a bill for an act to amend the Supreme Court Act to provide authority for the making of rules to regulate the active management of civil and criminal matters before the court.
Second. Oh.
Thank you, Senator the Honorable Ryan Pinder.
So I got to do the second one.
The second one? Okay. It has been moved and seconded that the following bill be read for a second time and committed. A bill for an act to grant a right of election.
Supreme Court.
Yeah, we're doing, sorry, I grabbed this.
No.
Supreme Court.
My bad. Do the Supreme Court.
Supreme Court first.
What we didn't do is.
Yeah, that's what he moved.
We're doing it as a compendium.
Okay, all right. It has been moved and seconded that the following bill be read for a second time and committed. A bill for an act to amend the Supreme Court Act to provide authority for the making of rules to regulate the active management of civil and criminal matters before the court. As many as in favor say aye.
Aye.
Those opposed say nay. The ayes have it. Order the bill be read for a second time and committed.
A bill for an act to amend the Supreme Court Act to provide authority for the making of rules to regulate the active management of civil and criminal matters before the court.
For the second reading.
Thank you, Madam President. I move for the second reading of a bill for an act to grant a right of election to persons charged with indictable offenses in the Supreme Court to be tried by judge alone, and for the consequential amendment of miscellaneous provisions of law and for connected purposes.
Second.
It has been moved and seconded that the following bill be read for a second time and committed. A bill for an act to grant a right of election to persons charged with indictable offenses in the Supreme Court to be tried by judge alone and for consequential amendment of miscellaneous provisions of the law and for connected purposes. As many as in favor say aye.
Aye.
Those opposed say nay. The motion is carried. Order the bill be read for a second time and submitted.
A bill for an act to grant a right of election to persons charged with indictable offenses in the Supreme Court to be tried by judge alone and for the consequential amendment of miscellaneous provisions of law and for connected purposes.
For the second reading of bills,
There are none, Madam President.
Committee of the Whole.
Madam President, I move that the Senate do now resolve itself into a committee of the whole with the Vice President in the chair.
Second.
It has been moved and seconded that the Senate do now resolve itself into a committee as a whole with the Vice President and Chairman of the Committee of the Whole in the chair. As many are in favor, say aye.
Aye.
Those opposed, say nay. The ayes have it. The motion is carried.
Committee of the Whole.
Thank you, Mr. Chairman. With respect for a bill for an act to grant a right of election to persons charged with indictable offenses in the Supreme Court to be tried by judge alone and for the consequential amendment of miscellaneous provisions of law and for connected purposes, I move that the long title of the bill be agreed.
Is there a seconder?
Second.
It has been moved and seconded that the long title of the bill be agreed. As many are in favor say aye.
Aye.
Those who oppose say nay. The motion is agreed.
Thank you, Mr. Chairman. Mr. Chairman, I move that the short title of the bill be agreed.
Second.
It has been moved and seconded that the short title of the bill be agreed. As many are in favor say aye.
Aye.
Those who oppose say nay. The motion is agreed. The short title is agreed.
Thank you, Mr. Chairman. Mr. Chairman, I move that clauses 2 through 16 of the bill be agreed.
Second.
It has been moved and seconded that clauses 2 through 16 of the bill be agreed. As many are in favor say aye.
Aye.
Those who oppose say nay. The motion is agreed. Clauses 2 through 16 are agreed.
Thank you, Mr. Chairman. Mr. Chairman, I move that the schedule of the bill be agreed.
Second.
It has been moved and seconded that the schedule to the bill be agreed. As many are in favor say aye.
Aye.
Those who oppose say nay. The motion is agreed. The schedule is agreed.
Thank you, Mr. Chairman. I now move that the bill be agreed in its entirety.
Second.
It has been moved and seconded that the bill be agreed in its entirety. As many are in favor say aye.
Aye.
Those who oppose say nay. The motion is agreed. The bill is agreed in its entirety.
Thank you, Mr. Chairman. Mr. Chairman, now with respect to a bill for an act to amend the Supreme Court Act to provide authority for the making of rules to regulate the active management of civil and criminal matters before the court, I move that the long title of the bill be agreed.
Second.
It has been moved and seconded that the long title of the bill be agreed. As many are in favor say aye.
Aye.
Those who oppose say nay. The motion is agreed.
Thank you, Mr. Chairman. I move that the short title of the bill be agreed.
Second.
It has been moved and seconded that the short title of the bill be agreed. As many are in favor say aye.
Aye.
Those who oppose say nay. The motion is carried. The short title of the bill is agreed.
Thank you, Mr. Chairman. I move that clause 2 of the bill be agreed.
Second.
It has been moved and seconded that clause 2 of the bill be agreed. As many are in favor say aye.
Aye.
Those who oppose say nay. The motion is agreed. Clause 2 of the bill is agreed.
Thank you, Mr. Chairman. I now move that the bill be agreed in its entirety.
Second.
It has been moved and seconded that the bill be agreed in its entirety. As many are in favor say aye.
Aye.
Those who oppose say nay. The motion is agreed. The bill is agreed in its entirety.
Thank you, Mr. Chairman. Mr. Chairman, I move that Madam President do now take the chair.
Second.
It has been moved and seconded that Madam President do now take the chair. As many are in favor say aye.
Aye.
Those who oppose say nay. The motion is carried. Madam President will now take the chair. When, this morning or last night? Yeah.
Bahamas like that. Bahamas, you can just come to a pocket of rain, and then it's dry spot. It's crazy. It's like a different world.
The fires in Coral Harbor still going? They out. Because last night I could even smell the smoke where I live. Yeah. It happened. What about the fires in Andros?
I don't know. I hit no mutton for the season.
Madam President, I beg leave to report that the Committee of the Whole has examined both bills, having made no amendment thereto.
Honorable members, the Vice President and Chairman of the Committee of the Whole has reported that the committee has examined the bills, having made no amendments thereto. Third reading and passing of bills. Chair recognizes Senator the Honorable Michael Alcides.
Yes, Madam President. Madam President, I move for first reading. I move for third reading and passing of a bill for an act to grant a right of election to persons charged with indictable offenses in the Supreme Court to be tried by judge alone and for the consequential amendment of miscellaneous provisions of law and for connected purposes.
Second.
It has been moved and seconded that the following bill be read for a third time and passed. As many as in favor say aye.
Aye.
Those opposed say nay. Or that the bill be read for a third time and passed.
A bill for an act to grant a right of election to persons charged with indictable offenses in the Supreme Court to be tried by judge alone and for the consequential amendment of miscellaneous provisions of law and for connected purposes.
Order that this bill do now pass, and the title thereof declared to be Trial by Judge Alone Miscellaneous Provisions Act 2024. For the third reading of bills. Chair recognizes Senator the Honorable Michael Alcides.
Yes, Madam President, I move for third reading and passing of a bill for an act to amend the Supreme Court Act to provide authority for the making of rules to regulate the active management of civil and criminal matters before the court.
Second.
It has been moved and seconded that the following bill be read for a third time and passed. As many as in favor say aye.
Aye.
Those opposed say nay. The motion is carried. Order that the bill be read for a third time and passed.
A bill for an act to amend the Supreme Court Act to provide authority for the making of rules to regulate the active management of civil and criminal matters before the court.
Order that this bill do now pass, and the title thereof declared to be the Supreme Court Amendment Act 2024. For the third reading of bills.
There are none, Madam President.
Consideration of House amendments. Resolutions. Discharge of select committees. Notices for future meetings.
Madam President, I renew all notices in the name of the government.
Orders for clerk. Adjournment.
Madam President, I understand that I will just I move that the Senate at its rising do adjourn sine die.
Is there a seconder? Second. It has been moved and seconded that the Senate at its rising do adjourn sine die. As many as in favor say aye. Okay. Just before I put the question, Senator Ellis wished to have a few words.
Thank you, Madam President. I just wanted to, on behalf of our side of the table, wish Senator Barry Griffin, the Vice President, a happy birthday. I've known Barry since he was a law student, And so it is an honor to serve with him in this place.
Would you like to do this now?
Thank you, Madam President. Also, Madam President, just before the question is put, I want to, on behalf of all senators, to extend condolences to the family of the late Miss Latonya Mackey, especially her mother, Mrs. Joyce Mackey. Latonya Mackey was the sister of Mrs. Rosemary Mackey, who works at the House and at the Senate. She assists us greatly in our function, enabling us to carry them out. And so we share in your loss, and we just want to ensure your family that you will remain in the prayers of, particularly Madam President, and all of us as you go through this time of bereavement. Ms. Mackey is to be laid to rest this coming Saturday. I think the funeral is at Bethel Baptist Church on Meeting Street. Condolences to the family.
Thank you, both Senators Michael Ellis and the Honorable Michael Keys. Thank you, both senators. As many as in favor say aye.
Aye.
Those opposed say nay. The nays have it. The motion is carried. I said that. Sincere apologies. I was reflecting on the condolences by Senator Michael Alcides, who extended condolences to Rosemary Mackey on the passing of her sister. All right, let's try that again. As many as in favor say aye.
Aye.
Those opposed say nay. The ayes have it. The ayes have it. The motion is carried. Final adjournment.
Thank you, Madam President. I move that the Senate do now adjourn.
Is there a second?
Second.
It has been moved and seconded that the Senate do now adjourn. As many as in favor say aye. Aye. Those opposed say nay. The ayes have it. The motion is agreed, and the Senate stands adjourned. Sine die.
Sentiments.